permanent impairment rating examinations for workers' comp claims to be performed by physicians mutually agreed upon by employers and employees or appointed by the Director of the Department of Labor. First, we have the Director of Labor, or his designee.
He was here.
Yeah, I saw him.
Yeah.
If Dwight comes back through, we'll bring him back up to the mic. Daniel Nellis, Dole Food. In opposition, Doug Ewert, South Pacific Steel. In opposition, Gary Warmoth, Queens. Opposition, Ralph Inouye. Opposition, Mark, small business owner. In opposition, Milia Leong. Submitting comments, Pam Kirk. In opposition, SHRM Shrim Hawaii. Opposing, AFL-CIO. Support, Workers' Injury Medical Association of Hawaii.
I'm going to summarize, Mr. Chairman. We believe that...
George, if you could speak into that mic.
Sorry.
Yes.
We believe that this bill is the fairest way for a injured worker to get a independent medical exam. Our detractors have said this is the only tool they have. We're not talking about tools here. We're talking about fairness. We want to make sure that it doesn't escalate where one side asks for an IME, the other side doesn't like it, and then they escalate this thing. By having an agreed to IME, where both sides agree to who's the doctor, who's in the specialty, that we can eliminate this problem right here and fix the problem with the injured worker. Thank you very much.
Thank you very much. NFIB. In opposition, Property Casualty Insurers. Opposition. Captain? Anyone else wishing to testify on this measure, please?
Good afternoon. Barbara Krieg, Director of the Department of Human Resources Development. We did submit our testimony ahead of time. I'll summarize that here, and then if you'd like, I can leave a copy of it for you.
Sure.
To start, DHRD administers the state's self-insured workers' compensation program. It's in that capacity that we have submitted our testimony and I'm testifying here today. To summarize the testimony, we strongly support Section 3 of the bill, which would provide additional resources to DLIR's Disability Compensation Division. Even without the additional burden of administering the proposed bill, they work long and hard. They have a lot of issues they have to deal with, and we believe they could benefit from additional resources. We do, however, have very strong concerns about Section 1 of the bill, the part that would have both sides having to agree on the IME. To summarize the fundamental concern we have, it is that you already start out with the presumption of compensability. That's an employee-favored presumption. You also have an employee with the ability to seek physicians of his or her choice. Again, that's the employee choice. So we do see this as the balance on the side of the employer to determine whether it's a compensability issue, whether it's later issues of ratings. And that is the reason that we have submitted our testimony, and those are, in essence, those are our concerns with the bill.
Thank you.
Thank you.
If you could give it to the clerk, he'll get it to all of us. Is there anyone else wishing to testify on this matter?
Good afternoon. My name is Douglas Thomas Moore. I submitted previously on behalf of myself my testimony and support, but I'm changing my hat a little bit because I am the president of the Hawaii Injured Workers Association, which is a broad-based coalition of injured workers. They're treating physicians, folk rehab people, therapists, attorneys, et cetera, et cetera. We strongly support the passage of the mutually agreed IME concept. We have for years. We've seen too many abuses where doctors who the only thing they do is to work for employers and insurance companies to render negative decisions against the injured worker. And then the problem is medical treatment's cut off, The problem is the rehabilitation process is stopped, and then we just get into litigation. We'd like to take as much litigation out of this process, and we think that mutually agreed IME, just like mutually agreed PPD impairment rating doctors, is the way to go. Thank you very much.
Thank you. Please.
Good afternoon. My name is Janice Fukuda. We submitted written testimony. I'm the Assistant Vice President for the First Insurance Company, and I'm testifying on behalf of the Hawaii Insurance Council, which is a nonprofit association of PNC companies licensed to do business in Hawaii. We represent approximately 40% of all property and casualty insurance premiums in the state. Hawaii Insurance Council opposes this bill. And the basic reason is that it denies employers and insurance companies due process to obtain a second opinion regarding the etiology of a medical condition that may or may not be related to employment or the work injury. In response to physicians that solely do independent medical exams, I don't know any of them that is their sole practice, so I'm not sure where Doug got that information. Employers seek clinical expertise to help return injured workers to the job. There are numerous safeguards currently in place to ensure that the IME is objective and unbiased. And injured workers can also obtain their own independent medical exams as well. I believe that the current system does provide for a check and balance, and that it's working in the majority of the cases. This bill will actually prolong the process in that if there is no mutual agreement, then both parties then have to go to the Department of Labor. What if the physician next on the list isn't available to do that appointment? It may not also serve the injured worker in that it requires two separate appointments, one to do the independent medical exam to address medical care, the other one to do an impairment rating. Another portion of this bill also puts certain restrictions on limiting the treating physician as the only person that can declare an injured worker medically stable. The bill also changes the definition of medical stability. We consider this to be problematic because there is no check and balance. The treating physician then has carte blanche to continue treatment. There's no incentive because there's no check in place. So we believe that this bill should be held. Thank you.
Terry Costa.
Hi, Terry Costa, injured worker. Sorry for submitting my
It's fine.
papers late. I'm in support of this bill based on being an injured worker. I had an examination while I was on narcotics, and it seems like during the examination he never mentioned that I was on these narcotics. If you look at this report that I submitted, the second page you'll see medications. It doesn't mention any narcotics. I was on the Vicodin. I had a shoulder surgery for rotator cuff. I got injured in 2007 for a back-related injury. While performing physical therapy, I couldn't complete my physical therapy because I had a torn rotator cuff. When I went to repair that in May, as soon as I got out, I had this IME done. And during this examination, I explained to the doctor that I couldn't even move my arm, and that I wanted a pain medication. But he never mentioned it in his report. If you go to the third page, my treating physician was Dr. Calvin Oishi, who states on the medication narcotics. And then the fourth page will just explain that I was on pain medication while this IME was performed. The bottom line is, if we don't allow people to have a mutual agreement as far as getting an IME and just allow the insurance carriers to send you wherever you want to go, where they want you to go, and have this bogus report printed out, it's been affected me since 2007. Treatment denial, medication denial, all based on this report which wasn't conducted fair. All I'm asking is just have a fair exam. Well, in 2010, the next page, I asked for an IME again. This time, after having a hearing on June 24, 2010, the insurance carrier's representing attorney stated that I failed to attend the examination. I did not. I simply asked to reschedule the examination because I was having a functional capacity evaluation done in July 21st, 2010. So my treating physician at the time, Dr. Lau, said, hey, don't do the IME on June 28th. Wait till the FCE is done to get a fair IME examination. Well, this is the letter they sent to the Department of Labor saying I failed to attend the examination, upon which I filed a fraud complaint against the attorneys for saying that, because I never requested a PDR. On that first page, they're saying a claimant requests a permanent disability rating. I never did. I requested another IME. So upon the answer to complaint, the attorneys hired another attorney to represent them. When we appeared at the hearing in 2011, December 1st, they stated that I didn't respond within the deadline on the 14th. And they said I was 1 day late on the 15th. I didn't fail the examination. I simply just said to reschedule it. And then the last page will show that I did send an email on the 14th, which they failed to even acknowledge that I even asked them on that day to reschedule my appointment. So there's a lot of hassles as far as just trying to get a fair IME. And even when they sent excuse me. They get a chance to make a copy of this. Even when they sent all their emails to the DCD, they left out that June 14th email, because that would have clearly showed that I responded within the 10 days of that fraud complaint. Now, nothing's being done about this. I had numerous hearings, and nobody wants to address the issue of the bogus IME report. There's no law. There's nothing they can do. He's pretty much free to do whatever he wants and whatever he wants to say, and it affects the injured worker. All I'm asking is just a fair IME. That's it.
Stick around, we may have some questions, but I appreciate it. And I particularly appreciate you sharing your personal story.
Thank you.
Do we have another? Please. Director, the mic is yours.
Chairs, members of the committee, good afternoon. We appreciate the opportunity to present testimony. I think we've submitted our testimony, and in support of the measure, we would like to acknowledge and appreciate the work that members of the committee put into this measure last year, and would be available for questions at the appropriate time.
Thank you. Thank you, Director. Do we have anyone else wishing to testify? Please.
Hello, my name is Deborah Luckett. I'm the Vice President of Workstar Injury Recovery Center, and I'm here to represent the 10 physicians at Workstar who were unable to attend today because they're diligently trying to provide care to the backbone of the state of Hawaii, the blue-collar worker that is injured at work or on the highway. This bill, Workstar is clearly in support of, and I would have to take great aim, I think, at First Insurance. This is what is First Insurance worried about? Why couldn't we have first of all, if a physician is paid and hired by an insurance company, I want to know how they're delivering an independent medical evaluation. Secondly, the physician that's hired by the insurance company is paid about $4,000 to do an exam that a physician in our office would be paid about $200 for. Third, if the physician doesn't deliver or deny the care that the insurance company wants to deny the patient, they're going to fire them. Fourth, I don't know, and I'd like to see the list from First Insurance of all these physicians and these private practices, because I don't know any of them that have private practices. And fifth, the insurance company is letting somebody that has a degree in ophthalmology deliver a render, something that's, taking care of this poor man's life. His benefits, his health care. They're letting somebody, an ophthalmologist, that's an eye doctor, deliver a render a decision that's going to impact a worker's life for the rest of their life on a musculoskeletal injury. So I want to know how that's fair. So I want to say we come out very strongly on a mutually agreed upon IME physician. I don't think that's asking too much. And I would say, what do they have to hide?
Thank you, Deborah.
Thank you.
Thank you. Kai Fujimura, IOW. We have submitted testimony. I want to go on record in support of this bill. We believe that the process that's being proposed would restore the integrity to the IME system. And I would reiterate what's been said. I mean, when it boils down to it, it's individual workers' lives who are trying to get back to work, getting back to a sense of fairness, being able to function. And for some reason, the IME system is not delivering that. There's a real sense and a feeling that there's an unfairness built in terms of how it's operating now. The proposed change to a selection process, we believe is analogous to a grievance arbitration process, where there is a panel that you select. It doesn't have to be exactly like this, but there's a panel of arbitrators. The union and management have picks in terms of getting down to one arbitrator, and the arbitrator then hears the case and rules. And sometimes we win one, we win, we lose, but there is a sense of fairness and acceptance of the fairness of the process, and that's what we're trying to achieve in this bill. Once again, we support the intent and the particular process that's being proposed in the bill. Thank you.
Thank you, Guy. Chamber, please.
Hi. Thank you, chairs and members of the committees. I'll stand on my written testimony. We did submit testimony. I did want to emphasize that the bill is based upon the erroneous presumption that employers routinely abuse their limited right to discovery through employer-requested examinations. And the results of these examinations are subject to review and appeal by the employee and must be credible enough to withstand the scrutiny of DOIR's review. But I did want to say that we do support Section 3 of the bill. So thank you for the opportunity to testify.
Thank you, Sherry. Is there anyone else wishing to testify, please?
Thank you, Mr. Chair. My name is Dennis Chang. I've been a practicing labor and workers' compensation attorney for 36 years now. I previously submitted my testimony, and I just want to echo what was said by other people in support of this bill. Other than that, I have nothing more to add unless there are questions later. Thank you.
Anyone else wishing to testify?
The city and county did submit a testimony in opposition late. We apologize for that. If you don't have a copy that we provided to you, we'll just have a testimony.
Thank you. Director Dwight, can I ask a couple questions?
Sure.
Basic questions. Just for perspective, if someone goes through the IME process and is denied and then it gets appealed, what's the general time frame and what are the challenges that are posed? I just am wondering about, timely care, that kind of thing.
You're talking about appeal levels or just within the first determination?
I guess both might as well.
Okay, let me try to cover real quickly just the appeal process, okay? Because Workers' Compensation Chapter 386 is a little bit special. As the legislators are aware, most administrative hearings, administrative decisions, once they get appealed, go to circuit court. Okay, so workers' compensation is a little bit different. Initially, the Department of Labor addresses the conflict and issues a determination. Within 20 days, that can be appealed to the Labor Appeals Board. Now, Labor Appeals Board is de novo. In other words, whatever record was put together at the first level, you start all over again. Okay, and it is an administrative hearing. Generally, it tends to be a little bit more technical than the first, and then the Labor Appeals Board will issue their determination whether they overturn, whether they preserve the decision or modify it in any way. Their decisions then get appealed to essentially the Supreme Court level. The Intermediate Court of Appeals may handle the appeal. That's a 30-day period for either party to do that appeal. Okay, so that's sort of the bigger picture, the overall structure. With respect to the initial decision, I know that a number of measures have come before the legislature trying to tweak, the process. But essentially, you have in this bill two issues. One is compensability. That is the injury covered by the work comp law at all or not? And a lot of times you have that IME, the doctor's opinions, because in workers' compensation, pretty much the determinations are based on what the medical evidence shows. That's why IMEs become so critical, and you're hearing all of this input. The second issue, of course, is extent of permanent disability, and that is where you have a so-called IME to determine what is the extent or how much permanent disability resulted directly from that industrial injury. And so those are the two parts that are being presented to you. It seems to me that compensability is a lot of times, the key determinant, because either you're in or out. And so whether you obtain benefits and how quickly you obtain benefits becomes a key concern. Because I think you hear from different claimants, depending on their circumstances, what barriers they ran into. But you can understand that if the employer, insurance company, determines that they don't feel it's compensable and therefore will not pay for any of the bills, there can be a delay, sometimes a substantial delay in our departments following through on our responsibility to resolve that. And because of some of the staffing challenges we've been faced with, the delay caused, which is sometimes utilized. I mean, most of the parties, in good faith, follow the process, but generally you have that minority that will take advantage of the process, possibly taking advantage of knowing that hearings take time to play the system. And I think that's in part why, you hear from the parties you're hearing today. Again, I think the department's experience is that most of the parties, play by the rules. And then you have those few that tend to create some of the stories you're hearing about. So again, I didn't give you a total timetable, but that's sort of a sense of at least the issues involved in this measure from our perspective.
Director, thank you.
One question. You may not be able to answer this, but if this bill were to become law, would there be an impact on insurance premiums?
That's a good question, Senator. And, again, it would depend on, I think, the outcome. Would changing the law, change the outcome, and in what manner? Okay, if these are independent medical examinations, you would think that there wouldn't be a significant impact because then, the doctors are being straightforward and all of that. What you're hearing from the different parties is that, this whole sense of whether there's hired guns and whether that changes the fairness, of the system, and whether the economic capacities of either party then has impact on that, again, on the issue of fairness. That's why I think it was wise for, the members on that side of the table to do a drop-dead clause, because we see what the adjustment to the workers' compensation rates are every year, because the insurance commissioner monitors that. And actually, just big picture again, in the past decade, the rates have dropped by more than 60%. Okay. However, in the last 2 years, we've seen that sort of, perhaps bottom out a little bit, and this year there was an increase of 5.2%. So again, if compensability, changes any, and if it's more in favor of the claimants, perhaps you might be seeing, medical costs or other benefits, right, that would come as a consequence of a more favorable compensability ruling, possibly adding to the cost. Again, NCCI generally is the body that, tries to look at each piece of legislation and come up with their own assessment on what the change in cost might be.
Okay, thank you.
Thank you very much.
Thank you very much, Director. Members, any other questions? Let's move to our next measure, Senate Bill 876. This is also a workers' comp bill authorizing the employer and provider of services to notify the Director of Labor and Industrial Relations in the event of a reasonable disagreement relating to specific medical service charges. First, PCI. In opposition, is there other testimony in this measure?
Once again, DHER did submit our testimony in advance, and we'll make sure that we submit another copy here. And once again, our testimony is in our capacity as the administrators of the state's self-insured workers' compensation plan, meaning the taxpayers' money being paid for claims. We oppose this bill. We oppose this bill on the basis that the measure is unnecessary, that there already is a dispute resolution process in the medical fee schedule. Virtually identical, but the significant difference is that the medical fee schedule, which is itself has the force of law, has a definition of what is a provider who can take advantage of that dispute resolution process. If this goes into statute, there is no corresponding definition, so the consequence would be that third parties, debt collectors or others, would have standing to then avail themselves of the dispute resolution process with the DLIR. Given the DLIR's other concerns, the burden already on the Disability Compensation Division, and what we believe to be unnecessarily trying to put this in statute where the process already exists with the force of law, we oppose the measure. Thank you.
Thank you. Any other late testimony? Yes, please.
Okay, I'll try to be less emotional this time. I'm here again with the Workstar Injury Recovery Center, and we strongly support this bill. Senate Bill 876. I find it interesting. I'm sorry, the person from the state said that there was something in place for resolution. Well, I would say it's not working because right now there's over 1,900 outstanding claims. And I don't know how many of you have to run a business, but we do. I paid, as this young lady mentioned earlier about the taxpayer's dollar, Workstar paid a tremendous amount in payroll taxes, employee benefits, and the GIT tax. To date, of the 1,900 claims, probably 40% of them belong to Workstar. They've been sitting in the queue for 6 months. So, according to the Hawaii Administrative Rules, HAR 2012-1594, it says that there's a reasonable disagreement and the payment of the billing shall be increased by 1% per month of the outstanding balance. I'm not quite sure where 1% per month came from because Visa and MasterCard charge 18.75%. And that in the event of the disagreement, the employer shall pay for all acknowledged charges and shall notify the provider. Well, none of that's been done. And the state has provided every physician's office in the state of Hawaii that dispenses a 35-page, and that's just the cliff notes of the rules and regulations for dispensing, which we have complied with. All of these prescriptions are medically necessary, and yet people with far lesser degrees than an MD degree, which an MD went to school for 10 to 12 years and comes out with at least $200,000 in debt, people with high school educations, probably not even a college education, are sitting there telling us this isn't medically necessary. So I would like some resolution. I would like for it to work. I'd like to get paid so we could stay in business and continue to support the over 50 people that alone Workstar employs, which is far more than HIMIC, one of our largest work comp carriers, employs. And so, to conclude, we strongly support Senate Bill 876, and thank you once again. We've been in business for 23 years providing care to over 20,000 people and restoring them to their duties and their activities of daily living. So we've got a lot of expertise. Thank you very much.
Thank you, Deborah.
Good afternoon. Kathy Wilson with Automated Healthcare Solutions. I'm just going to strongly support this bill. In regards to the service fee, we would propose that a $500 fee be payable to the state's general fund per claim on the basis of an effort to prevent carriers from continuing to engage in this improper reimbursement tactic. Sorry, a little
It's all right.
nervous. Also, in consolidating the disputes for multiple disputes of the same venue to be batched together so that could be processed more quickly. And then maybe a 60-day payment provision that that the language, it's in the resolution rules, but we think that maybe putting it in the statutes would help prevent the carriers from not paying and having to have these disputes get tied up in the Department of Labor. Thank you.
Thank you very much. Anyone else wishing to testify?
Again, my name is Dennis Chang, and I'm also a member of the Hawaii Injured Workers Alliance as a director. I'm testifying as an individual as well as on behalf of the organization. We strongly support the intent of this statute, but we do have concerns here, and mainly two of them. The first is, we have an overburdened disability compensation division at the present time, and I think that needs to be taken into account. There may be some due process violations, although we must give the director credit in moving forward in trying to codify having a hearing process by statute. The second point is, I think there needs to be a strong look at what is the average wholesale price and what goes into that determination. Right now, from my perspective as an attorney, I have no idea, what goes into that determination, and I think that needs to be defined and investigated further. Thank you.
Thank you. Gentleman in the back.
Good afternoon, Senator Green. My name is Chris Kozalava. I'm with Solera IMS. We're a payment integrity vendor in the workers' comp and automobile insurance markets. And we are opposed to this measure. And I think in the interest of time, I would defer to Deher's testimony. I think that it very succinctly summarizes our first concern with the bill. And secondly, the bill makes the department's decisions unappealable. And while I'm not an expert on constitutional law, I believe that would violate the state constitution, as it would constitute a taking without the right of due process. That right of the department's decisions being unappealable were part of the dispute resolution rule that already exists in the Hawaii administrative rules. That's 121594D. And that was removed after the Intermediate Court of Appeals decision in Joe versus Hamada in 2009. So the Intermediate Court of Appeals already weighed in on that issue, and I believe it would be found unconstitutional. So I would urge you to remove that if you were to pass the bill. Secondly, the bill also removes a key pricing control, capping provider reimbursement of private patient charges, and I would urge you to reinstate that language. And if the intent of the bill truly is to codify the bill dispute resolution process in the statute, I would really ask that you just carry over the language from HAR 121594D because that process is one that has served us well, over the past 20 years that I remember that I've been in this industry. And, I have to say that I also want you to take a look at where these disputes are coming from. The state of Florida just recently reported in business insurance a fourfold, 400% increase in total bill disputes in the state of Florida. They reported a roughly 1,000% increase in bill disputes in Florida, and they're saying that these bill disputes, the reason for these bill disputes are a result of the physician dispensing and the outrageous drug markups that are being attempted to be charged in the marketplace. And while I don't know the exact statistics from our Department of Labor, maybe Director Takamine could clarify, how many of the 2,000 or so bill disputes that they currently have on dock are due to prepackaged drugs and physician dispensing. Thank you very much.
Okay. And I'll deflect that question to D. Hurd in a moment.
Thank you.
Okay.
Thank you.
Sure.
Thank you.
Thank you, Chair Green. HIC submitted written testimony earlier, and I just want to echo previous testimony in opposition of this bill. And I believe that no one individual entity should have sole jurisdiction over controverted matters, and that either party should have the right to appeal. Thank you.
Thank you. Did I see someone else wishing to testify? D. Hurd, can I ask you a question? Just clarify for me. I was a little confused. You said that there already is in place a dispute resolution mechanism.
Right, that's in the medical fee schedule. That's what the previous testifiers referred to.
Right. So what's the process right now? I guess that what's at issue is there's an impasse about when there's a dispute.
Actually, we handle the claims administration for our employees, but that would be a question, I think, for Director Takamine, because it's his department, DLIR, that actually handles the billing disputes. Our concern is there already is such a backlog. There is a process, but what this bill would do is basically keep the same process in place, but allow others who are normally now don't have standing to go through the process to do it. So it would add to the number of billing disputes that are already pending before DLIR. And that's one of our concerns.
Okay. Director, can I ask? So what would be the effect if this bill were to pass?
Okay. Maybe I can start out this way. Yeah. Both DHERD and Department of Labor are part of one administration. Right. And I think, on workers' compensation or other areas, I think where we come together is that both departments wants the best and the fairest workers' compensation process. Okay, I guess after that, because of our areas of responsibility, we tend to go separate ways. So whereas DHERD has to look at it from the employer's perspective, because that's the role that they play, right? And they have to be concerned about the costs, et cetera, et cetera, et cetera. We come at it from a little bit different perspective, and that is, as the administering, department or agency, we have to be sure we don't lose sight of the purpose of the workers' compensation law in Chapter 386. And so, coming at it from that standpoint, actually, we would disagree. Rather than creating more work, the hope is that, as a result of sort of the potential legislative action, that attention being focused to this billing dispute concern would actually allow us to handle it more proficiently. There's about 19,000 industrial injuries every year. Okay, so you can imagine that, if all of them went to dispute, we'd be drowning. We wouldn't be able to, in any meaningful way, carry out the intent of the law. Right. But for the most part, the system works, okay, because the parties take reasonable positions and they're able to work out, their differences, the disputes. It's only in those categories where the parties cannot do it that it comes to our attention. So focus back on this issue. On billing disputes, there are about 17,000 plus billing disputes before the department currently. And as the DHERD director indicated, basically the bill does codify what is in the medical fee schedule, which is a rule and regulation. Okay, so that's why she indicated it does have the force and effect of law. because that's the status of our rules and regs. However, I think what has happened is because our department has not been able to deal with this issue in an efficient manner, left to their devices, steps have been taken by both parties so that the number of cases really have mushroomed. We're in the process now of trying to deal with it more adequately and in a more meaningful manner. Okay, and the hope is that by establishing landmark cases, that will provide guidance so that rather than every billing dispute automatically, rather than looking, at the factual circumstances and determining, well, can't we resolve this? That would occur. I have no crystal ball. I cannot predict the future, but we are engaged in that process. We took the position of supporting, the measure because, again, the hope is that, I guess, except for a couple tweaks, in essence, what is being codified is what is in the rules and regulations. Okay, so there are a number of good points that have been raised by the employer side. One of which being, whether any decision can be appealable. And we did have, while our rules and regs essentially covered the same, I guess the same language as the statute or the proposed statute, there was a court decision that did knock down that provision, which, said that any decision made by the director is non-appealable. However, we were advised that, it might be an issue that the legislature could possibly change. But perhaps this is one area that it would be worthwhile to, have, I guess, the legislative attorneys, take a look at and see whether or not any change would be warranted should you decide to move the measure forward. So, I'm sorry, in a nutshell, that's sort of the status, and if you have any further questions, I try to answer them as best as I can.
Thank you, Director. Chair, do we have any other questions for Director?
Thank you.
Wait a minute, sure. Did you, some more testimony? Sorry. Okay. Thank you, Chair.
Good afternoon, Chair and members of the committee. My name is Jerry Nichols, and I'm the Workers' Compensation Program Manager for the City and County of Honolulu. We had provided our written testimony. It was late, as we apologize for that. And we do reiterate our opposition to HB 876, and we stand on our written testimony.
Okay, thank you very much. Anyone else wishing to testify on this measure?
Just add one more thing. I do think that the process has changed very significantly, and specifically the way the process works now is we get into billing disputes with providers, and we usually negotiate them out, and they never see the Department of Labor. I think in my career in the last 19 years, maybe we've done 100 bill disputes. We do it's a handful every year. We have probably 1,000 pending, and that's all due to physician dispensed drugs. The difference in the process that we find very unsettling is that the Department of Labor has acted as a gatekeeper for these disputes, meaning they qualify the dispute and they put both parties on notice to negotiate. This bill removes that process. It basically anybody can request a bill dispute, and it has been limited, by the rules. But now anybody can request a bill dispute, and I think what we've seen in the marketplace over the past couple of years is a lot of bullying by collection agencies, by collection companies, and their tactics were, they'll call one person in our office, hang up on them, call the next one, hang up on them, call the next one, hang up, call the next one. They'll resubmit the same information 8 or 9 times without providing any of the information that we actually requested in order to certify payment for that. So we're afraid that if this bill passes, these collection agencies will just step up their bullying efforts on the payers, and unfortunately the Department of Labor, I think, on the back end is going to end up with a whole lot more work than they have now, because they do control the process now. They can control it. Here, anybody will be able to start a bill dispute, and once it runs its course, everybody has to do all the work to draft the position statements for the department to review. And once you get to that, I think the department will have a lot of work. I mean, right now, if they're facing 1,700, I think Dwight, Mr. Takamini said 17,000, but I think he meant 1,700.
Thank you.
Thank you. Thank you. I do think it will be a very heavy burden on the department to have to administer the process on the back end versus being the gatekeeper as they currently are on the front end and making a decision. Like they currently do. We've worked with the department, like I said, for 19 years. They've been very fair, very timely about administering the bill dispute process. And again, it's very thoroughly codified in 1215-94D. I did submit late written testimony, so I apologize for that. I'd be happy to pass on a copy to you if you don't already have it. But in there, I took the language from, I think, 1176, and put it into 876. And made a red line of the language that's been changed, so you can have a thorough review of the language that's been changed. But it does completely change the process. Thank you. Thank you very much.
Thank you. Okay, members. So what we're going to do is going to stretch your legs, kind of recess for 5 minutes. Then we'll be back to hear Senate Bill 1109. We have to defer Senate Bill 1264 until a later date, which we've already scheduled due to a re-referral, and we will get that bill moved. And then we have Senate Bill 666. So I'll be back in 5 minutes.